Senator-elect, for one, stated that it is clear that the president lied when he testified before the grand jury. Congressman Meehan stated that the president engaged in a dangerous game of verbal twister. Indeed, the president made false statements to the grand jury, and then that same evening spoke to the nation and criticized all attempts to show that he had done so as invasive and irrelevant. The president's approach appeared to contravene the oath that he took at the start of the grand jury proceedings. It also disregarded the admonitions of those members of Congress who warned that lying to a grand jury would not be tolerated. It also discounted Judge Susan Weber Wright's many orders in which she had ruled that this kind of evidence was relevant in the Jones case, and thus ended the over 8-month journey that had begun on December 5, 1997, when Monica Lewinsky's name appeared on the witness list. The evidence suggests that the 8 months included false statements under oath, false statements to the American people, false statements to the president's cabinet and his aides, witness tampering, obstruction of justice, and the use of presidential authority and power in an effort to conceal the truth of the relationship and to delay the investigation. Given the serious nature of perjury and obstruction of justice, regardless of its setting, it is obvious that the actions of the president and Ms. Lewinsky to conceal the truth warranted criminal investigation. Let me explain how the investigation came to be handled by our office, rather than by the Department of Justice or by some other independent counsel. That explanation is straightforward. On January 8, an attorney in our office was informed that a witness, who was Linda Tripp, a witness in prior investigations in our office, had information that she wanted to provide. A message was conveyed back that she should provide her information directly. Ms. Tripp called our office on January 12th. In that conversation and later, she provided us a substantial amount of information. Let me pause here and emphasize that our office, like most law enforcement agencies, has received innumerable tips about a wide variety of matters over the past 4 years, from Swiss bank accounts to drug smuggling. You name it, we have heard it. In each case, we must make an initial assessment, whether it is a serious tip or a crank call, as well as an assessment of jurisdictional issues. We handle the information from Ms. Tripp in the same manner. When we confirmed that the information appeared credible, we reached out to the Department of Justice, as we have done regularly during my tenure as independent counsel. We contacted Deputy Attorney General Eric Holder within 48 hours after Ms. Tripp provided us information, and we found him appropriately at a basketball game in the evening hours of that day. The next day, we fully informed the Deputy Attorney General about Ms. Tripp's information, about Ms. Tripp's tapes and the questions concerning their legality under state law, about the consensual FBI recording of Ms. Tripp and Ms. Lewinsky, about the indications that Vernon Jordan was providing employment assistance to a witness who had the potential to harm the president, a fact pattern that we had seen in the Webster-Hubbell investigation, as I shall describe presently. We discussed jurisdiction. We noted that it is in everyone's interest to avoid time-consuming jurisdictional challenges. We stated that the Lewinsky investigation could be considered outside our jurisdiction as then constituted. We stressed that someone needed to work the case, the Justice Department or an independent counsel. Later that evening, the Deputy Attorney General telephoned and reported that the Attorney General had tentatively decided to assign the matter to us. Before her decision was final, We reviewed the evidence in detail with two experienced career prosecutors in the Justice Department. One senior Justice Department prosecutor listened to portions of the FBI tape, the consensual recording. The Attorney General made her final decision on Friday, January 16. That day, through a senior career prosecutor, the Attorney General asked the three-judge special division to expand our office's jurisdiction. The special division granted the request that day. In short, our entry into this investigation was standard, albeit...
You are watching live coverage of the House Judiciary impeachment hearings from CBS News.
7 months later, after conducting the factual investigation and after the President's grand jury testimony, the question we faced was what to do with the evidence. The chairman referred to Section 595C of the Independent Counsel Statute, which requires an independent counsel investigating possible crimes to provide to the House of Representatives, in the words of the statute, substantial and credible information that may constitute grounds for an impeachment. This reporting provision suggests a statutory preference that possible criminal wrongdoing by a president be addressed in the first instance by the House of Representatives. It also requires an analysis of the law of impeachment. You have had hearings on that subject, but let me say that as we understood the text of the Constitution, its history, and relevant precedents, it was clear to us that obstruction of justice in its various forms, including perjury, may constitute grounds for an impeachment, the language of the statute. Even apart from any abuses of presidential authority and power, the evidence of perjury and obstruction of justice required us to refer the information to the House. Perjury and obstruction of justice are, of course, serious crimes. In 1790, the first Congress, sitting in New York, passed a criminal law that banned perjury. A violator was subject to 3 years' imprisonment. Today, federal criminal law makes perjury a felony punishable by 5 years' imprisonment. In cases involving public officials, courts treat false statements with special condemnation. United States District Judge Royce Lamberth here in Washington recently sentenced Ronald Blackley, the former Chief of Staff to the former Secretary of Agriculture, to 37 months imprisonment for false statements. The district court, Judge Lamberth, stated, in his words, "The court has a duty to send a message to other high-level government officials that there is a severe penalty to be paid for providing false information under oath." Although perjury and obstruction of justice are serious federal crimes, some have suggested that they are not high crimes or misdemeanors when the underlying events concern the president's private actions. Under this theory, a president's obstruction and perjury must involve concealment of official actions. This interpretation does not appear in the Constitution itself. Moreover, the Constitution lists bribery as a high crime or misdemeanor. And if a president involved in a civil suit bribed the judge to rule in his favor or bribed a witness to provide favorable testimony, there could be no textual question that the president had committed a high crime or misdemeanor under the plain language of Article 2. Even though the underlying events would not have involved his official duties. In addition, virtually everyone agrees that serious crimes such as murder and rape would be impeachable even though they do not involve official duties. Justice Story, in the last century, stated in his famous commentaries that there is not a syllable in the Constitution which confines impeachment to official acts. With all respect, an absolute and inflexible requirement of a connection to official duties appears fairly viewed to be an incorrect interpretation of the Constitution. History and practice support the conclusion that perjury in particular is a high crime and misdemeanor. Perjury has been the basis, as the committee knows, for the removal of several judges. As far as we know, no one has questioned whether perjury was a high crime or misdemeanor in those cases. In addition, as several of the scholars who appeared before you testified, and to whom the chairman referred, perjury seems to have been recognized as a high crime or misdemeanor at the time of the founding of our republic. And the House Manager's report in the impeachment of Judge Walter Nixon for perjury stated, "It is difficult to imagine an act more subversive to the legal process than lying from the witness stand." And finally, I note that the federal sentencing guidelines include bribery and perjury in the same guideline, reflecting the common sense conclusion that bribery and perjury are equivalent means of interfering with the governmental process. For these reasons, we concluded that perjury and obstruction of justice, like bribery, may constitute grounds for an impeachment. Having said that, let me again emphasize my role here. We had a judgment to make, but whether the president's actions are in fact grounds for an impeachment or some other sanction is a decision in the sole discretion of the Congress. A final point warrants mention in this respect. Criminal prosecution and punishment are not the same as or a substitute for congressionally imposed sanctions. As the Supreme Court stated in a 1993 case, the framers recognized that most likely there would be two sets of proceedings for individuals who committed impeachable offenses: the impeachment trial and a separate criminal trial. In fact, the Constitution explicitly provides for two separate proceedings. The framers deliberately separated the two forums to avoid raising the specter of bias and to ensure independent judgment. Our task over the past several years has involved far more than simply the Lewinsky matter. The pattern of obstruction of justice, false statements, and misuse of executive authority in the Lewinsky investigation did not occur in a vacuum. In August 1994...
Mr. Chairman, I seek a ruling of the chair. Mr. Chairman. I seek a ruling of the chair.
Well,
Mr. Chairman.
All right. What is, I take it the gentlelady has a point of order?
Yes, I do, Mr. Chairman.
State your point.
Mr. Chairman, I respectfully raise this point of order with the understanding that we have not received, or we're not receiving, any referral on the issues dealing with Madison Guarantee, Whitewater, Travelgate, or Filegate. And in fact, as I understand, there is an announcement today that the findings of guilt against the president on the issues of Travelgate or Filegate do not exist, referred in pages 46 and 47 of the statements of Mr. Starr. I therefore ask, Mr. Chairman, whether Mr. Starr's remarks, as he begins them at this point, are germane, and secondarily, whether or not the president is being denied his Fifth Amendment rights by lack of notice and a denial of liberty by not having been noticed of any presentations being made on Whitewater, Madison Guarantee, Filegate, and Travelgate. I believe Mr. Starr's remarks are now out of order, and I believe that that there should be a ruling that his remarks are not germane, and frankly that if he proceeds, he will be denying the president and any other parties the constitutional right of due process in the Fifth Amendment. And Mr. Chairman, as you well recognize, I raised this question when we began some 2 or 3 months ago, whether or not this committee would abide by the constitutional provision of the Fifth Amendment. I offered an amendment to that extent. I would